Yeah, next speaker is Mr. Stefan Mathias, who's the partner of Kochhar and Co. And he would be taking us through the topic, the legal aspect of cloud computing. Small bio. He is a partner in charge of the Bangalore office of Kochhar and Co., a leading law firm in India. He represents some of the world's largest information technology companies, and his work involves setting up software development and BPO centers in India, software licensing, e-commerce, and outsourcing. He is active in representing international companies in doing acquisitions in India and is a leading M&A lawyer in technology industry in India. He has also experience of doing acquisitions relating to public listed companies in India. His other area of expertise is venture capital investments. Now I would request Stephen to come on stage and take over the dais. Thank you.
Good afternoon, everyone. I'm not sure any of you expected to come for a cloud computing conference and be addressed by a lawyer talking about law, but I can assure you that there are many legal issues in cloud computing that you need to be aware of. Obviously, cloud computing presents many advantages for you, but there are many risks as well. Essentially, what we are seeing in the world today is a movement away from control, that is controlled by the enterprise. You have social media on one hand, where, for example, you could be exchanging information over LinkedIn that is not controlled by the company. You could have people coming to office using their own devices, what we call BYOD, where again company information is not located just on a company-owned laptop or on a company server, but is being synced and taken out of the office. And then, of course, you have cloud computing, where you are going to be using applications that are not in your premises, or you're going to have your data outside your premises. So loss of control means increased risk, and that is something you have to be careful about, and you have to consider what remedies you need to take to manage that risk. If you look at a typical software license contract, or most contracts in the software and hardware space, what you will find are standard clauses. For example, you'll find a disclaimer warranty. There are no implied or express warranties as to fitness or merchandise, blah, blah, blah. And basically, software is provided as is. And that's largely because that's the way the software industry is. The only warranty typically provided is that if a third party claims intellectual property infringement, then that's a warranty you give. But again, the remedy there is to change the software so that infringement goes away. The other big issue is limitation of liability. So typically, again, here, indirect consequential losses is something you cannot claim from the service provider. There may also be a pecuniary limitation, so you cannot claim damages of more than X amount. So these are typical provisions that you find in a software contract. But what about cloud computing? What about, let's say, data? Let's suppose you have your data in a third-party server, and that server crashes and you lose your data. How valuable is that? Invaluable. What remedy could you possibly have? Pretty much nothing. The only thing you could have is to sue the pants off that service provider for millions and millions, and even then it may not recover what is irrecoverable. But in the software space, you will typically not get that kind of a remedy, because standard provisions in the IT industry apply as well to the cloud computing space, which means that instead of getting remedies in a contract, you might need to take practical measures to safeguard yourselves. Choosing a service provider is hugely important. And my perception here is that in cloud computing, you might just find there's a very high threshold for a startup, because trust is a huge issue in cloud computing. And perhaps this is an area which will be dominated more by big, reputable companies, because you'll be very concerned, especially about your data, handing over your data to a startup, to a small company without much of a reputation. In cloud computing, you could lose a lot more if there's lack of business continuity. So in the software world, you may lose access to the software, or you may lose access to maintenance for a particular period. But in cloud computing, you may not be able to transact, you may not be able to do business, and even worse, you may not be able to access your data. Due diligence then becomes quite important. You've got to know who this vendor is. You must understand his financials. You probably need to know a lot more about his technical capability, about what hardware and what technology he's using, where it's coming from, who are the service providers, and so on. The one thing I would recommend as a lawyer is that before a customer moves to cloud computing, he should put in place a cloud computing policy. In other words, he must determine what does he want to use cloud computing for, in what manner will he use it, and what kind of protections does he want. And if he doesn't get those protections, then what's the remedy? A kind of solution as to how you will use cloud computing is important for a customer. Merely just going into cloud computing without understanding the risks will harm you. As I mentioned, business computing far more important in cloud computing because businesses cannot function if it can't access if they can't access their applications and their data. What you would typically find here is a bit of a negotiation between the customer and the service provider. The customer will want a hard warranty saying that you will provide, that there will be no downtime. They will ask for an uptime commitment. They will ask for penalties for failing to meet that uptime commitment. The service provider is unlikely to provide that. So getting some kind of SLAs is probably the way out. And sometimes we have actually found a customer might buy those SLAs. In other words, the customer may pay extra money to get those SLAs. Very important here, and effectively you're looking at a practical and a business solution to a legal problem, because the customer, the vendor is not likely to give you what you want in the contract. It's important to understand carve-outs for uptime commitments as well. The service provider is justified in mentioning certain types of carve-outs. For instance, some downtime may be caused by the customer, lack of quality of infrastructure from the customer side. For example, viruses that may attack the customer may hurt the data as well. So those are things that the vendor is justified in carving out. Scheduled maintenance is probably the one big one. Just a clause that the vendor can, implement scheduled maintenance whenever he wants is just not good enough. You need to know what is the scheduled maintenance, when is it, how long is it, and perhaps plan it with the vendor so that it happens at a time perhaps when you have the least need for the system. And then, of course, there's security, perhaps the biggest issue of all. So here, of course, again, the customer will tell the vendor, we want you to provide the best security possible. The vendor is unlikely to provide you any kind of commitments. The wire media here is to have some kind of security policy, some kind of security standard, and the vendor should commit that this particular security standard, that's what we are following, and we are committing that we will follow that. And then what happens if the vendor does not follow it, and how do you know whether the vendor is following it or not following it? So you could have a right of audit, but audit is a tough thing. It costs money. It's difficult to do. Confidentiality is a big issue. The vendor is managing systems for many companies. How do you just look at yours? The other method is certification, and probably that's the way to go, to insist on some kind of annual certification that the vendor is following those security standards that he claims to be following. How you store your data is also important, both from the perspective of the customer as well as from the vendor. So the customer may want to categorize data appropriately. It may look at certain data and say, okay, this can be maintained in the public cloud. Other kind of data should not be maintained in the public cloud. Maybe it should be maintained in the private cloud. Other type of data, which is very sensitive, the customer may want to back it up himself in his own facility. So the customer needs to determine how exactly he's going to use the cloud, in what manner, when it comes to different types of data, which may have different degrees of sensitivity. And then how the vendor is going to back up, store that data is also important. For example, is there going to be intermingling of data with other customers? If so, will there be a problem tomorrow separating that data? And we'll see there are several other problems associated with intermingling of data, or even using common servers. Where the servers are located is also important. In terms of the data being located in less risky countries. You know, there's risk involved in being in a country that's very heavily regulated, but a very stable country. There's risk involved in being a country that's not so regulated, but maybe not so stable. So having servers in an unstable country could be a problem. It could be the subject of terrorism. It could be the subject of poor IT and telecom infrastructure. There could be much more downtime in these countries. And you could also have government intervention, which could be a problem. So this is something else that a customer needs to consider. On the other hand, if you go to a country that's a stable country, you will probably find that that country is more heavily regulated. You need to be concerned about the possibility that regulatory authorities may pull data or may pull systems down. You may have heard of the mega upload case, where the US government went after an online pirate website, and they pulled the servers down. And when they pulled the servers down, they also pulled down websites of many legitimate companies, with the result that, poof, suddenly a whole bunch of companies just went off the web. A huge problem here. So how the vendor stores the data, on what servers, where those servers are, is also important. You have an even more recent case in the last couple of weeks, where the government and the ISPs in India have been blocking the same online pirate websites, like Pirate Bay, for instance. And here again, the government action is without much logic. So ISPs have just gone and blocked a whole bunch of websites without thinking clearly as to what are those websites, what exactly are they doing. Why is that happening? That's happening because under India's telecom laws, the ISPs have agreed that they will not allow any copyright infringement to take place. So what that means is the government can just issue an order to an ISP saying, take down the site. and they have to take it down. Whereas the proper way of doing this is to go to court and make an allegation against a particular website and say, this website is engaging in copyright infringement, and then the court will pass an order for taking down that website. Whereas if you have a government order which simply asked for particular servers to be pulled down, then that could be an overreach and could hurt much more than what is intended. You should also consider when a solution is offered, is that solution entirely offered by the vendor, or are there third parties involved? You probably need to read that contract carefully, because the contract might say somewhere that the vendor is not responsible for any third party products or services being offered, even though those services, that solution is being offered by the vendor, and it's not a third party solution that the customer is using. So that's something you should also be careful about. Interoperability and open standards is a crucial issue when it comes to migration. You want to get off from this particular vendor and you want to move to another vendor, or you want to move back into your own facility and stop doing cloud computing. You might have data in a particular format. You might have data that's intermingled with other people's data. How do you separate all that? How do you get your data back and then be able to access and use that data again, perhaps with a different software? Of course, these issues are not uncommon. They are already faced in the IT industry. But with cloud computing, you have less control because that data is not with you, it's with somebody else. And so getting some commitments from the vendor here in the contract is also important, so that he helps you out, and you need to understand what kind of help you need from him and how much it's going to cost. If you don't factor that into the contract, then he could ask anything he wants. Anyway, he's losing the customer, so he can ask for anything he wants, and you're in a way blackmailed. So this is something, again, you need to be very careful about. When it comes to data, you have privacy laws. Some are industry specific, some are laws that apply across the country. The US, you will have, for instance, healthcare, where you have HIPAA. You have in the financial industry, several regulations. So if you want to provide services to, say, a US company, then the customer and the vendor have to consider about the data being moved. What kind of role will that vendor play? What is his position under those laws? What does the customer need to get the vendor to accept, and what does the vendor need to implement? So all these things you'll find in these specific laws, and you need to consider that industry-wide. You even find in India there are some regulations. For instance, the RBI has regulations for banks that want to outsource. It has some very queer language which says something like, you can outsource to a country only if the data is not subject to the supervision of the authority there, merely because the data resides in that country, whatever that means. So it's so ambiguous, this language, that it becomes very hard for banks and financial institutions in India to have data stored outside India. Similarly, if you look at the telcos in India, the carriers in India, there are regulations that prevent remote access and which make cloud computing difficult if it involves an offshore solution. So privacy in general, you have countries that have privacy laws in general that set standards for how you can receive data, what you can do with that data, how you safeguard that data. Europe is the best example. You have the European directive on privacy, and then you have each country with a law that implements that. So when it comes to data moving from Europe, you have to be careful about this. But even India has some rules on privacy that were issued in April last year, and you need to be careful about that. One key aspect that you will typically find is a rule which says that you cannot send the data to another country unless that country has a law that provides the same level of protection for privacy. So which means you have to check what the law is in that country and whether it has the same level, and if it does, then you can send it there. Be mindful of tax issues. I sometimes wonder whether cloud computing is like a reverse flat world. You've heard the phrase flat world, which Thomas Friedman talked about in his book. And essentially what he was trying to say was that with the advancement in telecommunication, countries like India are able to compete with the westernized developed countries because telecommunications has made the world flat. But perhaps we will see a reverse scenario now where overseas product companies, if they want to sell to India and to Indian businesses, they don't have to come, set up over here, implement, customize. It's all done over the web. It's all cloud computing. But there are tax issues involved as well. And the tax issues are basically, even though the service is provided from overseas, the payment may still be subject to tax. And as the customer, you may be required to deduct the tax at source. So that is something that you have to keep in mind. Your finance people should be aware of that. One of the things that I thought of is that when you're managing your IT systems yourself, you might set a particular standard. It may not be a very high standard, but when you send it out to someone else, then you might demand a much higher standard. So perhaps that's not fair. But on the other hand, if they are the experts, and if you are relying on them because they are the experts, and essentially you're giving up what you don't want to do so that they can do it for you, then maybe they should be subject to a higher standard. So that's my presentation. Just to recap, as I said, keep in mind IT contract provisions that normally apply in the IT world don't exactly fit cloud computing because the risks are higher, but you may not get the extra protection in the contract. So you need to consider what are the practical business and technology solutions that you can find that can alleviate that risk. Thank you.
On behalf of Stefan, if there are any questions from the audience, we'd like to take them now. Are there any? Okay. So on behalf, you have one? Yeah. Sorry. Yeah.
See, earlier in your presentation, you said you need to do due diligence on the cloud service provider, his financials, and so on. But how do you actually get that information? If that flow is privately held, you won't get access to that information. How do you know? How do you prove? I mean, how sure to yourself that he's not going to go bust? You're going to take your money and go bust. He's not a fly-by-night operator.
It's a very tough situation, undoubtedly. I think that if it's a big company with a big reputation, they're not going to give you anything. If it's a small company, they might give it to you. But you should also note that annual financials for companies in India are actually available online with the company registry. So you can actually get the financials for any incorporated Indian company. The privately held ones as well are also available online, not just the listed ones.
I have one more question here. Excuse me. When you define SLS, is it legally binding? when you define SLAs, is it legally binding on the companies?
Yes, of course. It's a contract. It has obligations, and the obligations have consequences. And it's as long as both parties have agreed to it, it's legally binding.
Hi, my question is related to the privacy law. You said that personal information cannot be moved from one country to the other unless the other country has the same privacy law. What about applications like Facebook?
So it depends on what kind of information is involved. Typically, this information relates to sensitive personal information. So that could, for instance, under Indian law, cover financial information, but mostly it relates to medical information, political orientation, sexual orientation, and so on. So that information, yes, it cannot be transmitted. But the issue with Facebook is that you are putting that data on yourself. So if you open a Facebook account and if you put certain personal information there and it stores on, say, the Facebook server in, let's say, Singapore, then it's not as if Facebook is taking your data and transferring it, but it's you who are doing it yourself. So in that case, the law would not, this particular provision would not apply.
Okay, thank you.
Thank you very much.
So on behalf of UBM India and the Cloud Connect team, I'd just like to hand over a token of our appreciation.